Welcome everyone to IoT and IP Explained. My name is Claudia Tapia. I'm very happy to have you with us today. Last time we talked to Rubén Cano about AI and IoT. We left a couple of things open for discussion, such as the AI Act and the Product Liability Directive and the AI Liability Directive. And that's why I invited him to come today. So, Rubén, thank you so much for coming again.
Thanks to you. My pleasure to be again with you.
So let's continue our discussion, if it's okay.
Yeah, of course. Data portability is important. We have lots of rules stepping in. We have data portability right, for instance, under the General Data Protection Regulations. There's the Digital Services Act and related regulation, DMA. I believe, and I'm wrong, have also some rules in order to enhance or make it easier for that data to be portable in a way. And that's very important, I believe. I mean, the problem data portability is willing to solve is the following one. We don't want just one company, the company that is having the data, benefiting from its usage. We ideally want to give some rewards to the company that is generating that data, and without removing or the benefits and the incentives that a company have, make for the whole, let's say, ecosystem to benefit from that data. So the data portability is interesting because you port data, you move data from one company to another company. Problem being that sometimes data is not in the same language. I mean, the language is different, right? Hopefully enough, AI may also help solving this problem through, I don't know, any protocol people much more smart than me can create, right? And this is a game changer. Because once you have more data available, more conclusions, it's like if I have a secret and I don't share it with anyone, right? If I have some valuable thing and I've already made some revenue, or I have been rewarded for developing that and creating that, whenever you can share that with more people, and that's, I think, has a positive impact that actually is kind of the principle governing all the IP system, right? Some incentives, rewards, sharing, creating. I mean, how much I create and how much I'm given, and what incentives do I have if I'm sharing things with others, right? So I think the how to make like a square from the circle, right? How to just find a way to make that data portability workable in practice.
I think it's so important to remember and remind also the audience that IP is mainly also about sharing. Because I hear this has been this huge lobbying machinery in the last years where IP has been pictured as something terrible that is blocking, that is avoiding innovation. And we have seen also very often the case that companies, if they don't have other ways to protect, they keep it secretly. So by creating a system where companies are incentivized to sharing, getting some compensation for this, we can actually foster innovation.
Mm-hmm. Yeah, and I completely agree with you. Also, another thing, a lot of small companies only have intangible ideas, meaning they don't have they cannot deploy a huge industrial machinery. Is a way that also to foster the creation of businesses in the lower range of, let's say, the business. So whenever you have a good idea, the only idea that can be implemented, translated, expressed, whatever, the only way you have to protect it is intellectual property. So it is a way, as I think of it, is a way also for the people that may not have a huge amount of money to invest and to deploy some industrial processes to create something and be protected.
Yes, definitely. Let's talk a bit about the AI Act. It's supposed to ensure safety, compliance with fundamental rights, boosting innovation, all in one magic act. What can you tell us about it?
I don't know how will that result in practice. So I was yesterday. I was in an event with some colleagues, friends from the industry, and we're saying, yeah, but I mean, we're the champions of regulation in the European Union. We are, that's fantastic, right? We have the best regulations in the world and know how to regulate very well. But is that good for the business? Is that good for society? I mean, I think those are questions that the regulator is posing, and the regulator is, of course, replying. Sometimes I think we don't have a good balance. Let's put it that way, because we are putting a lot of pressures to companies and to all types of companies. Sometimes we think of very big companies we are considering regulation. And when I see the AI Act and I see some like very small businesses that have to implement all those rules, sometimes it's not easy to understand. I mean, the thing is, maybe at the end of the day, you may not have great impact, but you have to understand it. And you have to pay for legal services, which is good, if I may. Working
more than for others.
And I think it's a good conception, because actually the AI Act, in providing some general overview, divides it applies to AI systems or systems that have some degree of automation in order to work, and providing very simple definition that is not the same as provided by the law, but is some system that provides for some degree of automation. Can be a general purpose AI, meaning I'm resolving horizontal issues, or maybe a specific narrow AI, which are solving very specific problems, right? And in that ecosystem, the AI Act tries to differentiate AI systems depending on the risk they pose to the user. So we have actually prohibited uses, which are actually uses that generate a very high risk. Some example of that may be the use of AI for manipulating the user, for instance. For instance, using subliminal messages. That may be a use case for that is banned for the purpose of artificial intelligence, or mass surveillance. That's another purpose that is forbidden, and that's forbidden. Devil is in the detail. We go to the definition. We tend to, we want to go in the definition or go out the definition, but the purpose of the regulation is to do that. Then we have high risk AI systems, which are, for instance, the AI systems that are used for biometrics, that have your fingerprint and are doing things with your fingerprint, or the use of AI system for recruiting purposes. There are a lot of companies that actually provide software that help human resources to recruit people and to differentiate CVs, and all that is high risk, because we want to avoid discrimination, right? For that, we have a lot of obligations that go from self-assessments, some accountability obligations, and then at the end of the category, we have low risk, which is kind of all others that wasn't in previous categories. And there we have a lot of obligations to inform the user. One thing that was stressed from the very beginning of the regulation is that the user has to know whether he or she is interacting with an AI system, with artificial intelligence. So this also applies to IoT, because in the IoT system, sometimes when you're using a chatbot, you are interacting with the chatbot, and sometimes you don't know whether it is a chatbot or not. Well, if I'm interacting with a chatbot, I want to know, and I have to know whether I'm interacting, and also some additional details that have to be provided, right? We want to regulate AI, and the obligation will depend on the level of risk that the use case presents to the user. Another interesting thing is why negotiations were blocked in the last 3-4 months, even more, and with the eruption of generative AI, and how we regulate generative AI and foundational models, as they call it. But there we have some measures that try to help the regulate the authorities and the user to be more protected vis-a-vis those users. For instance, the developers of providers of generative AI models have to notify to the Commission that they have a generative AI model. They have to adhere to, actually have a policy to a copyright policy to comply with copyright rules. Oftentimes we have problems that we don't know where data is taken from. We don't know whether those data are protected or are not protected. So there is a huge problem with that as well. And that's being kind of, these obligations try to solve that problem, meaning that we don't know I'm thinking of the will of the regulator, which is a big presumption, right? But I think the regulator doesn't want to put too much pressure on the companies, saying, well, notify, I'm aware, and we will see how it goes. Well, whether it puts pressure or not, I have also an opinion that could give us for some 3-4 more episodes, but that's kind of the ecosystem, and the way that a lot of IoT systems, particularly those that are consumer facing, will have a great impact on by AI regulation. Also others, of course, in the application of AI-related legislation that actually pushes the company to have an AI governance mechanism, to know, to implement some also organizational measures that are not as such imposed by the legislation, but that you need. You need some organizational changes to know when an AI is about to be implemented in your company, because you have to do some assessments. So you have to actually devise some plan and to structure some organizational changes and some procedure in order to know when someone is thinking of that, to evaluate that, to implement the measures necessary, or decide that the AI doesn't have to be implemented, to do all the impact assessments, self-assessments, all that. I think
it's a lot of work.
That's a lot of work. And but a lot of companies, whenever we are thinking about AI, a lot of companies, most companies will have to do it if not covered by the exemption. And another thing,
and then they will call you.
And then I hope so. I hope so. And the territorial scope of the AI is quite wide as well. It also applies to cases where the company developing the AI is not based in the European Union, which also expands the territorial scope and makes companies that think that they're not covered under regulation fall just right under the scope.
Wow. Now let's go a little bit in the future, but even in the present, because we have talked about all this amazing technology. And I imagine, yes, we have all these amazing benefits, but what if suddenly there's a personal injury or damage to personal property that has been caused by AI, by robots or any other smart system, or data loss caused by unsafe products? Or are we protected in a way?
Well, I mean, I wouldn't dare to say whether we are or not protected. I think we have mechanisms that allow to claim protection, or to be to some extent sure that whenever we have a problem, we can request some compensation, let's say. And the effectivity of those, I mean, those are very recent. We have the Product Liability Directive that is reviewing the previous product liability regime, and also the AI Liability Directive that are kind of reshaping the ecosystem. And the effectivity of those will, I mean, once both of them enter into force, will be seen in some years, as any regulation we have, right? But what I believe is that before we weren't thinking of product that incorporated an AI system that could do things automatically without the intervention of a human being, or without the intervention of the manufacturer, of the distributor, or some individual in the or company in the supply chain. Now we have more legal or natural persons that are involved in the supply chain, that have to be also perceived by I mean, taken into consideration by the regulation. And also, very simply, I mean, software and AI, which when you go sometimes to the definitions provided by regulations, are not there, and you have to interpret. And then there's one who would say, no, this is covered under the regulation or the directive, and there's another say, no, but it's not explicitly written, so that is not covered. And that's one thing that is being clarified, and that allows the users to claim and seek redress. Sometimes it's not always money or compensation, it's just to the situation to be fixed in a way. So sometimes I think we are going a bit beyond the line, because the regime sometimes provides some polloius juris tantum, and they presume that it is some liability from a company when they're using AI systems, which is very contrary to the principles of Roman law, that tells you that whenever you're claiming something, and you are stating that something has happened, you are the one that has to prove that, not the other way around. But since the AI is presumed to be very difficult, very technical for the users to understand, and for the users to know, we are kind of switching the proof. And that may sometimes make things more complicated. I mean, there can be myriad of use cases that I haven't think of.
Wow. And in this regard, I assume the AI Liability Directive is also bringing some light.
Yeah, that's particularly the one I was mentioning when I was saying the shift of in the liability principle. This is maybe directed. I mean, is thinking of AI. The other of product liability is thinking of AI, but it's also revisiting. When I say the other, product liability directive is also revisiting some situation. I mean, the context as such. Because the previous one was, I don't know, from the 85 or something, or 86, 1986, 1985, some time ago. So actually, a lot of things have happened. So this review has also taken into consideration this, and the AI Liability Directive particularly focuses on AI, on that shift, because as I was saying, sometimes it's difficult to understand what's happening within the box and how all that interaction work. So I think that's the reason why.
Rubén, I think we can really talk for hours.
Yeah.
And thanks again for your time.
It was my pleasure, Claudia. Thanks to you.
That has been all for today's podcast. As always, we look forward to receiving your feedback. You can reach out in LinkedIn under Claudia-Tapia or via email at ipwithclaudiatapia@hotmail.com. Connected, we go further.